Good morning. Welcome to 2024 School Law 101 series. I'm happy to be the first presenter this year related to labor and employment law updates. Welcome to all of our new participants. Some of you may know we have some new additions that we're very excited to have. There are about 4 or 5 attorneys from Lambert Barnoski who started with us on January 1st. So we are excited to have all of their clients to be participating with us as well. So let's get started. I will keep us to a strict timeline. I know you guys are all in have busy days, especially with a snow day or a delayed opening or whatever you may have had this week. My name is Hillary Morera, for those of you who have not met me. I work out of our Garden City office on Long Island. I have been with the firm about 15 years. I'm a partner here, and I do labor and employment law, specifically in schools. So all of these topics that I'm going to talk about, I deal with on a daily basis. So our agenda for the day is the status of COVID leave rules. At some point in my life, I will stop talking about COVID, but it is not today, unfortunately. We're going to talk about some new and proposed civil service laws, the use of biometric technology, and obviously workplace violence, which I hope you all are dealing with at the moment. So the status of COVID leave. Well, to everyone's dismay, at the beginning of every calendar year, I always get a flurry of phone calls asking me, do we still have to give COVID days? And the answer, unfortunately, is yes. Those COVID days are still in effect. And I'll go over some of the limitations in a second. But there is no sunset date yet on their books. There was a proposed legislation to try to remove New York State COVID days from the law here in New York, but that has really gone nowhere in New York State legislature. So we're still cruising as though New York State COVID days is in effect and has not actually changed since March of 2020. I'll go over that in a second. However, some good news, I try to deliver some good news. The New York State vaccine leave, which went into effect in March of 2021, obviously that was shortly thereafter the vaccine was being rolled out. That expired December of 23. So it is officially expired. That was the leave where you were required to give up to 4 hours of leave to either get the vaccination or a booster. So thankfully that is gone, but the New York State COVID days are still in effect. And what does that mean? So currently there's still no expiration date as to when those COVID leave days are going to expire. But in January of 2021, even though this is not specifically in the law, the New York State Department of Labor issued guidance limiting the number of times an individual can use that leave of up to 3 times while they're working for you. So dating back to March of 2020, they could have used the New York State leave for a total of 3 times. I am often at this point getting the question of, well, how do I count whether or not they've hit their 3 orders of quarantine, such that once they've used it 3 times, if they test positive again, they have to use their own sick time. Well, so it's a little murky if you're looking back all the way into 2020. And that's because if you recall, there was, in addition to this New York State COVID leave, we also had the federal COVID leave that we were often giving people as well. That expired at the end of December of 2020. But during that time, these 2 things were running on parallel tracks. But sometimes my clients didn't code them very clearly. So you could have used that federal COVID leave for about 6 or 7 different reasons that you could not have used the New York State COVID leave for. So for example, if somebody had symptoms of COVID, which as we all know, symptoms of COVID is a symptom of the flu, of really anything, a headache, a sore throat, a stuffy nose, you could have stayed home, used the federal COVID leave, and then if you tested negative, then you had to come back to work. So if you did not code those properly and distinguish between which leaves you were giving, was that the federal leave or is that the New York State leave? It's difficult to use or to point or to say to a person that one of those times in 2020 would count as one of their 3 occurrences. So what some of my clients are doing is, as of January 1st, 2021, that federal leave, all those federal leaves expired. So therefore, going forward, 2021, anybody who was taking New York State COVID leave, that would likely be considered one of your occurrences. Now, what I want to highlight is that technically, like I said, the New York State COVID leave in the law has never changed. And remember, back in March of 2020, when we were first quarantining, it was 14 calendar days per occurrence. We all know right now that the quarantine requirement is 5 days. So don't, I want you to know this, but I don't also want you to telegraph this to people, because technically an occurrence is still up to 14 calendar days per occurrence, but they don't get to aggregate the days. So if for some reason, they quarantine for the 5 days as required right now, and they're still sick, there are additional days under the quarantine law that they can access. But for most people, if they come back to work and then they don't have access to the additional days. What an occurrence is, though, if you use one workday, that's an occurrence. You don't get to save up days. So, for example, if over the winter break I got COVID and I came back, my school started on January 2nd. And that was my 4th and 5th days of quarantine. So I've only used 2 days of the quarantine leave. That counts as an occurrence, even though I only used 2 days, whereas somebody else might use up to, 14 calendar days. So it's basically the number of work days that fall during your period of quarantine. And if there's at least one work day, that's an occurrence. One other thing that, just to be clear about, is that you don't have to accept, in order to show a positive test, you don't have to accept a home test. You can require employees to submit, and this is the guidance, documentation from a licensed medical provider or testing facility attesting that the employee has tested positive. So if somebody submits a home test with a doctor's note that says, based on the symptoms on this test, they should quarantine or they have COVID, then that's sufficient. But simply taking a picture of a home test that could be 2 years old, it could be of their kid, it could be of their neighbor, we don't know who it's from, they could have done it wrong, all these different things, you don't have to accept that to give them the quarantine leave. All right, so this is still in effect. Technically, hopefully that was all review, because technically nothing has changed. So this is still the same. And I promise, as soon as anything changes with this, we will have a blast out to everybody. Unfortunately, nothing is really moving on this front. Okay. All right, so new and proposed civil service rules. I hope that you guys are all aware of this. There was an amendment to Civil Service Law Section 63 at the beginning of September. This really does affect people that are appointed provisionally, and then whether or not you get a probationary period thereafter. And what the amendment did was that it gives somebody credit for the time they spent on their provisional appointment to their probationary appointment. And this, depending on how long somebody's in their provisional appointment, will reduce the amount of time in their probationary appointment to the point where somebody may not even have a probationary appointment. They may just go from provisional to permanent. So I just want to make sure everybody's aware of that. That's a big, big change, because sometimes, especially over COVID, when civil service wasn't giving tests out very often, people were sitting in a provisional status, sometimes for years. And then they would still have to do their probationary period after that, once they were taken out of that provisional appointment. That is no longer the case. So I just like to remind people of this, because sometimes clients have a tendency to be a little more lax with the reviews and evaluations and overall just kind of management of your provisional employees, because you always knew that you had their probationary period to look into all of those things as well. So be very careful that you should be treating your provisional employees just like you would a probationary, and they should be getting the same reviews, the same evaluations. And you can't sit on your laurels now thinking, oh, they're only provisional, so therefore I'll have time to really evaluate them when they're probationary. I hope this is also review, because it's been in effect since the beginning of September. Okay, some good news, which this is rare for me to report. I always feel like I'm reporting doom and gloom for employers, but as we all knew and we were watching very, very closely, was that there was proposed amendments to the civil Section 75 of the Civil Service Law. And the goal was to make it more like a 3020A hearing, which, as we all know, bringing a tenured teacher up on 3020A charges is very expensive. It's a very long process, and you don't always get the outcome. The biggest things in Section 75 that I always use and leverage in terms of trying to negotiate a resignation or some type of settlement were the two main things that they were changing. Number one, I get to pick the judge. I usually, and when I say I mean you, but anybody could really be the judge. It's the district's determination. But generally speaking, we pick a judge who we think is going to, see it the way we see it. And number two, upon service of charges, we were allowed to suspend people without pay for up to 30 days. Both of those things they were going to change. Shockingly, right before Christmas, late December, this got vetoed by the governor. And quite frankly, this was my face when I learned of it. I was absolutely, utterly shocked. It was a Christmas miracle. What I thought she was going to do, I didn't think she was going to sign it. I thought she was just going to do nothing. And when you do nothing, unless she vetoes it, it would have become law. And I thought she was going to take that kind of political way out. And she didn't. She affirmatively vetoed it. So for now, Section 75 remains as it was. And we'll see if additional proposals to change Section 75 get reintroduced. But for right now, it remains the same. And I'm happy to report some good news for once. All right. And I will touch upon this very quickly. This next one, Civil Service Law, Section 71 and 73. There was nothing specifically changed per se in the law as it relates to these two sections. However, there was a New York Court of Appeals case that I just wanted to bring to everyone's attention. So Section 71 and 73 are very similar in the sense of it gives the employer the ability to terminate somebody after they've been out of work for more than a year due to either an on-the-job injury or illness or an off-the-job injury or illness. And there are procedures for the termination. It's set by case law. We have to provide certain notice, give the employee an opportunity to respond, give them an employee to meet with the district representative, and then you take action at a board to terminate them. It's a way to, unencumber a position without having to go through the Section 75 process. And it's not considered a termination for misconduct or insubordination or something that you might discipline somebody for. It's just that they've been encumbering a position and they've been out of work for so long. We need to hire somebody, in a full-time basis. So despite the fact that the procedures that we had previously used for a very long time were set forth in case law, and that's kind of what we use, there was a recent New York Court of Appeals case that said that technically the procedures for termination under Section 71 is a mandatory subject of bargaining that you have to negotiate. Now, that case was specific to Section 71. I include Section 71 and 73 in this slide because they're almost identical, except for the way you count the year. But it's basically the same concept, except for one is on the job and one is off the job illness or injury. So keep that in mind when you're going through the process. But I always say, so for instance, I just had a client, we just terminated somebody who was out on out under Section 73, and the union didn't bring it up, and we have the past practice of doing it in that manner. And so we just kind of did it. And if they had asked to bargain it, because that obviously, can take a long time, we might have just brought them up under charges under Section 75. So you kind of have to weigh your options. You kind of have to know who the union is. I had a hunch in that case the union wasn't going to get involved. So just understand that if somebody asks to negotiate the procedures for termination under 71 and 73, it has now been determined a mandatory subject of bargaining that you may have to engage in. All right, use of biometric technology. So this one is also fairly new, and it kind of flew under the radar a little bit. So at the end of September, the commissioner finally issued her report. As you may recall, the New York State technology law had prohibited schools from using any biotechnology, fingerprints, facial recognition, a whole host of things until the Commissioner of Education was able to authorize the purchase and utilization. And what the commissioner had been waiting for, and it had taken a number of years, was a report that looked at how biometric technology was used, the credibility of it, and how it might affect certain have impacts on various diverse individuals of different races, and was it still accurate? Most of my clients were using, when this the technology law was passed that prohibited schools from utilizing biometric technology, they were using the fingerprint scanners to sign in and sign out. So they've had to stop doing that. But at the end of September, the commissioner finally issued her decision, and it said that schools are now only prohibited from purchasing or utilizing facial recognition technology, but they can use any other type of biometric technology so long as they consider the following: privacy implications, impact on civil rights, effectiveness, and parental input. So you have to, in order to introduce these types of biometric technology, I would at least go through those factors and at least evaluate them and document that you've considered all of those factors and then ultimately made the decision to use the biometric technology. Now, obviously, parental input, if I'm using for the staff to sign in and sign out, that's probably less of a consideration than some of the others. Privacy implications. When we, years ago, when we were rolling out biometric technology, and it was mostly the thumb scanners, the devices that we were using weren't really, it was more of a mathematical equation. They would take kind of an outline scan of your hand, and they, figured out some formula that they could tell it was your thumb, although they did not maintain your fingerprints. It's not as though the system was holding your fingerprints. And we used to have a lot of complaints about employees who didn't understand. They thought we were holding their fingerprints. And I kid you not, I had a complaint one time that they were afraid that ISIS was going to come and hack in to the system and take everybody's fingerprints. So, that's an extreme concern, but there are concerns about whether or not we're holding on to people's fingerprints or other type of, any type of recognition of ourselves or of the individual person. So generally speaking, those types of privacy implications you want to have. The impact on civil rights, is there a differing impact on one race versus another? Is it more apt to pick up one or have a false positive on somebody because of the color of their skin or something like that? So those are all the things that you have to consider. But by and large, it's a local decision. So you can decide whether or not you can use the biometric technology. The one caveat, obviously, from the labor and employment standpoint is, are there bargaining obligations for this? So as it relates to, signing in and signing out, if you already have a practice or it's in your collective bargaining agreement that people have to sign in when they get to work, sign out when they leave, then there are many cases that talk about the fact that you are allowed to unilaterally upgrade the technology. So if they used to sign in and sign out, maybe, 50 years ago, then they probably went to the key, a card swipe. That was easier. That was an upgrade in technology. If you wanted to do a fingerprint scan, that would be an upgrade to technology that you could unilaterally implement, as long as the process of signing in and signing out was something that you already have a practice or you've already negotiated. So just make sure you keep those in mind if you're including any type of biometric technology. All right, workplace violence, and I saved a lot of this presentation for this topic because I know this is something that you all are dealing with right now. And I want to give a little bit of background. So I've actually been dealing with this workplace violence statute for a very, very long time. We have a lot of clients that are municipalities that this workplace violence statute has been applicable to since 2006. At the time of its initial passage, school districts were simply excluded from the definition of public employers because you have to do your school safety plans, your building plans, all of those things. So I have a lot of practical advice on how we deal with this because we've been dealing with it for so long, even though it's new to schools. Because what I will say, for purposes of it being new to schools, they didn't change anything in the workplace violence legislation. All they did was eliminate the exclusion about schools not being considered a public employer. So everything else is still the same. I had one assistant superintendent of human resources ask me, this seems so antiquated. And what I said to him was, it is antiquated because remember, when this law was passed in 2006, was a totally different time. We're talking almost 20 years ago, when people didn't necessarily had to swipe in. There weren't necessarily, the doors weren't necessarily locked all the time. There weren't guards sitting at booths. You could just walk into a school building, maybe sign your name, maybe give an ID. It was a very, very different time. And you can see that things have changed. So a lot of my districts, I don't think you're going to have a lot to do, except initially it's going to be a lot of an additional paperwork. But realistically, in terms of, once you get through this initial part, then annually it's not that big of a headache each year. And we will, and I'll go through some of that. So technically in the law, it was this, for purposes of schools, was supposed to be effective January 4th. So you were supposed to have had all the requirements of the workplace violence program and the risk assessment and the policy done by January 4th. However, the Department of Labor updated some guidance and provided a more realistic time frame for all of you. So I wanted to highlight this. So the policy, which is the easiest part, it has to be adopted by February 3rd. So 30 days from January 4th. Now, I am aware February 3rd is a weekend. So by that Monday is, the Monday, it would be fine. What I've said to people is, listen, the policy is the easiest part. It's got to be passed by the board, and then you're supposed to post it around and disseminate it. Do that because listen, even if you don't hit any of these markers, what I keep saying is the workplace violence police aren't going to start knocking on your door and arresting you. But I do want you to show that you're making movements towards completing the policy. And I will explain why that will be important, because NYSET has been the driving force behind this. So I have a hunch that if schools are not complying and they're not meeting these deadlines, my guess is you're going to get some union presidents in your offices about the fact that there was a student fight and somebody had to break it up, or a teacher got hit by a student because the kid's in a kid is classified and that's, one of their behaviors and things like that. So I just want to take away an argument that they have. So please try to stick to these dates. But if you don't, again, it's not like the workplace violence police is coming to knock on your door, but we should all strive to get this done in time. So the policy from my perspective is the easy part. The next one, the risk assessment, that's the more complicated part. The risk assessment, and we'll go through this a little bit, is where you have to go around and do actually a physical inspection of all your buildings, your locations, and identify where it might be a higher risk that somebody might be the victim of workplace violence. So that has to be done by March 4th. Then the prevention program, which is you take your policy, you take your risk assessment, and you kind of put it all together in a program. That has to be done by the 19th. And then you have to have everything completed by May 3rd. And when I say everything completed, the last piece of the prevention program is the training of employees. You're required to train employees on an annual basis. The problem is, one of the requirements of the training is that you actually have to give them the risk assessment and the program and go through what you've identified as the higher risks and what you're looking to implement, or what your plan is to help reduce or mitigate those risks. So if you don't have that risk assessment done and completed, then you can't do the training. Or if you do the training, it's not sufficient and you will have to redo the training. So that's why they give some additional time after you've gotten the prevention program completed, to then obviously do the training by May 4th or May 3rd. So at least, I didn't know of any of my clients who had all of these done by January 4th. So at least this is, a little clearer as to where you should be, throughout the winter and the spring here. All right, school-specific implications. Now, this all came about, I kind of alluded to this beforehand. This came about from NYSET. They were pushing to include schools under the statute because they believe that this legislation is going to help address issues with students. As we all know, we can't predict what a kid is going to do. Whether or not a fight breaks out in the middle of lunch, or a classified student who has behavioral issues hits someone. Those are things that we deal with on a daily basis. This is really a political thing rather than something that I think is going to actually help teachers. They can say they got this, but it's just another thing that you guys are going to have to tick the box. So I just want to highlight the intent of it is just basically to require the district to look at workplace violence issue with an eye to help reduce or mitigate the risks. So obviously we're never going to eliminate the fact that kids might get in fights, or that a child with behavior issues might act out. It's what are we doing to address those things? So if we're not disciplining kids, so that might be, after we do the investigation, we say, yeah, look, students were getting in, these two students were getting in fights, so we disciplined them. That's how we're looking to reduce the risk. Maybe we find that there are large gatherings of students that are unmanageable in one location during lunch, and that is creating a higher risk of students. And when I say students getting in fights, the reason why that is important for you to learn is because obviously staff members come in and break those up, right? So if somebody gets hit in the process of breaking up those fights, or if a student turns around and throws a punch out at the security guard or a teacher or something like that, how are we addressing that? So other things you might want to look at is, like I said, if there's large gatherings without enough supervision, is there a way we can disperse kids in a more manageable way? Classified students, are we following their BIPs? right? If a kid has a BIP, we should be implementing it appropriately. And if we're not, that's the angle we should be looking at. Are we using our training? Have we been trained appropriately on the appropriate holds and the way that we address students, our classified students? And so those are the things that, quite frankly, you guys already do. Now we just have to write about it or document it when we do an investigation. It's like a different look as to how as to why workplace violence incidents happen. What I will say in my experience with my municipal clients is that once this initial assessment and the program is complete, it does seem a little bit of a challenge when you're first getting it together. Once it's complete, it's much more manageable on an annual basis. You basically, on an annual basis, review what you've already done. How are you doing in terms of implementing the ideas that you've come up with to mitigate the risks? And if you obviously build a new building, if you have a bond out and you've got a new building, you might have to do another inspection. But this initial assessment and program is where it is the most difficult. In my experience, after that, you really just have to remember to train your employees and to review at the end of the year, and it becomes much more manageable. So as we talked about before, there are 6 components to the law. There's the policy, the risk evaluation determination, the program, which is kind of encompasses all that, the employee training, the record keeping, and employee reporting and workplace inspections. In addition to having on an annual basis, having to do the training and, reviewing your program, there are employee reporting and requirements about, how many workplace violence incidents occurs. It's similar kind of like to Vader that you do for DASA. Obviously, you have to report to the Department of Labor, the workplace violence incidences. As we talked about the workplace violence statement, I want to focus on this because this is what you should be working on right now. So you got to develop, the statement has to be posted conspicuously. School Boards Association put out a policy. We have reviewed it in our office. There are a couple, it's pretty good. There are a couple of changes that you can make. Some of my employers just say, look, we like we are consistent. We like to have the School Boards Association policy, and we've adopted that. If in doubt, if for some reason, you can't get a whole different policy together by the deadline, adopt that. You can always amend it later on. But it's not bad. It's fairly short. It does not have a lot of the things that you're going to need to do for the program and things like that. If you want a few tweaks and things like that, let us know, but that is what you should be looking at right now. And as soon as you adopt it, get it up, because that's part of the requirement, that you adopt it and then you post it. The risk evaluation. This is the one that's going to take you the most time. You have to basically do a physical inspection of the workplace, and then the evaluation should be reviewed on at least an annual basis. You have to look at prior workplace violence incidents. So collating all that data can take some time. So make sure you're starting to pull those things, but you do have some extra time for that. The last thing is, the one thing that's required by law is that the employer, along with an authorized union representatives, they're supposed to be included in the process. Now, we recommend now, depending on your relationship with your union presidents and how many you have, quite frankly. So some of my districts have 9 bargaining units. That's a lot of people. If you're starting to, go all these different places and have to do a risk evaluation and things like that as to, a physical inspection. What I would say is that I usually bring the teacher union president in more than I would the others, but still have conversations with them. So what one of my districts is going to do is that they're going to utilize, mainly the teacher union president, and then before they finalize the risk evaluation, they're going to send it to the other union presidents to say, these are the things that we've identified and our ideas of, a mitigation of a risk. Let us know give us any feedback or thoughts, instead of bringing everybody around and having people being able to look at every, we want to minimize, we want to comply with the law because we have to include them, but we also want to minimize how much power and authority they think that they have. What I would also say is that if you want to bring all of your union presidents around, which that could be a daunting task, make sure you have more, what I would say, administrators or more supervisory people. So, from your administration team, than you do the union presidents. I don't want a situation where they think it's a vote and they think majority rules kind of way. So if there's ever I don't want the PR to say, oh, well, the majority of us felt that this was a high risk, but management didn't think that it was, so they didn't include it, right? That's a bad media blitz that I want to avoid. So obviously from my perspective, it's our decision, but you have to get their input and feedback. And the worst thing you can do is get input and feedback, and a lot of times basically tell them that you don't agree. And we can do that in strategic ways. But we got to just be strategic about the way that we, accept their feedback without them feeling as though, number one, that they are in power to tell us what to do and to tell us what the mitigating suggestions are going to be, or identifying the higher risk things. And number two, we want to make sure they still feel heard so that we can go out and say we've worked collaboratively together, because I do believe working collaboratively with your unions is the best way to go. But sometimes you get a union rep who is more challenging than others. So, that's just to keep in mind when you're thinking about it. Now, some people, somebody asked me, I'm no expert on determining what a high risk area is for workplace violence. Why am I the one doing that? Well, there's no real good answer to that. But these are some of the examples of what the Department of Labor has identified as a high risk situation to work at. Now, as you can see, as I've talked about before, this is prevalent. You can see that this is more applicable to municipalities, not necessarily to schools, right? So there's nothing in here really about students that they identified as these are the things that you should look at when you're doing an inspection. So you're going to have to kind of, I would include that, but just make sure, that you're looking at that separately. So anything that exchanges money, goods and services, duties that involve mobile workplace assignments. So if you have to travel from one place to another, if you're working with unstable people in a healthcare, social service, criminal justice setting, if you work alone, if you work late at night, if you work in high crime areas, duties involve guarding valuable property possessions, a community-based setting. Now that one is really school specific. Obviously, we're dealing with parents all the time. We have public board meetings. Oftentimes, schools are used as voting and polling places. So you often have extracurricular activities that community members can come, onto campus. It's closed, but we're still very open to the community, and you never know what's going to happen, who's coming and things like that. So that one is one that you're going to have to look at specifically, and working in a location with uncontrolled public access, right? So most of the time our school buildings are closed these days. However, you always find those doors that the teachers know to prop open so that they can come in and out, right? Even though they're all supposed to be locked. So those are the types of things that when you're doing the inspection, you got to look for. That yes, you have locks on all the doors, but are people closing the doors appropriately? Is there appropriate lighting over the doors? Is there lighting in the parking lots? Things like that. You all have, I can't think of any of my school clients who don't have 20 or more full-time permanent employees. So this all applies to you. You have to develop this prevention program. You had previously developed the school safety plans and things like that. A lot of my clients are finding that a lot of that can simply be modified to use for the workplace prevention program, because you've already identified a lot of the safety risks and things like that. So I always say work smarter, not harder. Don't reinvent the wheel if you don't have to, right? If you've already done the work and it's in your safety, plans already, utilize that without having to do everything again. And, the program, I'm just looking at my time here because I've got 4 minutes. So a program, you've got to list the factors, identify the methods the employer will use to prevent the workplace violence, a hierarchy of controls, things like training, and then what happens if the training fails, and potential discipline and policies and things like that. Let me see here. Employee training. You have to, like I said before, you have to provide employees with the information about the risks and what you're doing to mitigate those risks, which is why the training is last, because you have to do everything else before you can get to the training. But technically the training is part of the program. So you're not done with everything until you can actually train everybody. And you have to train everybody on an annual basis. So make sure you're adding that to the list of things that you have to do every year. That's sexual harassment, that's child abuse in the educational setting, that's a whole host of things. And I will say the training has to be, somebody asked me if they could use like a canned video. So there's no requirement like sexual harassment where it has to be interactive. The problem with the canned video is that you do have to provide specifics about the risks of the workplace and your specific program. So while you might be able to, as long as you can supplement some type of workplace violence training with more specifics related to you and your program, then that will probably be fine. But you can't just put on a video and be done with it. Let's see. Record keeping, and I just want to highlight this. It was something that we had. So Bond had created a workplace violence policy, and we had put in the record keeping requirements. It's not in NISBA's policy. It's not required to be in the policy, but it was something that when we were sending it out to employers, it was kind of like a notice for our employers to understand what the record keeping and the reporting requirements were. So if you guys, adopt NISBAs, don't forget, you've got record keeping requirements, and you have to report to the Department of Labor about various, the number of workplace violence incidents that have occurred and all those things. So make sure you reach out to whoever it may be. I'm 2 minutes before my time is up. If you guys have any questions, you can you can feel free to reach out to me or your respective contacts. And I'm happy to have started off 2024 and hopefully smooth sailing from here on out. Thanks, everybody. Take care.